Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss the case of Abhiram Singh versus CD Commachen, and this case is numbered at 67 in the list of AOR leading cases, and it is being decided by a 4:3 majority. That is, it is being decided by a 7 judges bench, wherein Justice T.S. Thakur, who was the then CJI, while this case was being decided, Justice Madan Lokur, Justice Bobde, and Justice Nageshwar Rao are writing the majority opinion, whereas Justice Chandrachud, Justice Lalit, and Justice Adarsh Kumar Goyal are sitting in the dissenting opinion. Okay. Now, basically, this particular case deals with Section 123, Clause 3 of the Representation of People's Act. Okay. So we'll look at what Section 123 is and what is the question that is arising in this case. Now, basically, if you look at Section 123, okay, Section 123 says that what are the corrupt practices with respect to elections, okay, to selection of candidate, election of candidates. And Clause 3 of Section 123 says that the appeal by a candidate or his agent or by any other person with the consent of a candidate or his election agent to vote or refrain from voting for any person on the ground of his religion, race, caste, community, or language, or the use of, or appeal to religious symbols, or the use of, or appeal to national symbols, such as national flag or the national emblem, for the furtherance of the prospects of elections of that candidate, or for prejudicially affecting the election of any candidate, provided that no symbol allotted under this act to a candidate shall be deemed to be religious symbol or a national symbol for the purpose of this clause. Okay. Now, basically, this particular clause, it is saying that this practice is a corrupt practice. Okay. And now, basically, if I am an election, I am standing as a candidate in election, and what I do, either me or my agent with my consent, okay, or any other person with my consent, if they refrain any voter, okay, if they tell any voter to vote, or if they refrain any voter from voting to for any person, okay, for any other candidate on the ground, or any other candidate or the same candidate who is, appealing or influencing the vote on the basis of election, on the basis of religion, race, caste, community, or language, or the use of religious symbol. Okay, now the court is basically herein is that, if you influence somebody's voting, taking some appeals of the religion, for example, saying I belong to religion X and the opposing candidate belong to religion Y, and so you know better whom to vote for. So basically, when you are invoking religion, or when you are invoking caste, when you are invoking community, when you are invoking language, that I am an X language speaker and that person is a Y language speaker, and you are good enough to know whom to vote. So that in that kind of cases, that practices will be called as corrupt practices. Okay. But now the question in this case is that when this term his is written, okay, this his term is in focus, that when I am making an appeal on the basis of his religion, now whether this his religion pertains to the candidate or it pertains to the voter as well. Okay, that is the question in this case. Okay, so whether it is candidate and voter, or whether it is only candidate and not voter, what is the interpretation of his religion, whose religion needs to be invoked as to call it a corrupt practice, whether it is the religion of the candidate or his agent on behalf of it, or whether it is the religion of voter as well, and whether it is the religion of both. Okay, so that is what we are looking into this case of Abhiram Singh versus CD Commachen. Now, basically, I already told you that there is a 4:3 majority in this case, and basically what happens is that this particular case dates back to 1990s, when the appellant Abhiram Singh wins an election in the Santa Cruz constituency in Maharashtra. Okay, now he contested and he was declared elected because he was voted higher in number. Now an election petition gets filed by his opponent CD Commachen, and it is under section 123 as well, and section 81 as well of the Representation of People Act, and it is contended, okay, it is contended by Commachen that he made communal statements during the election. Now, a three judges bench of the Supreme Court said that um, it was said that the content, scope, and what constitute corrupt practices under Section 123 needs to be reheard and needs to be decided by a constitutional bench consisting of five judges. Now, another case is happening at the same time, but that happens in Bihar. Now, it is the case of Narayan Singh versus Sundarlal Patwa. And even in this case, a corrupt practice was alleged to have occurred in the exercise of Section 123, Clause 3 of the Act. Okay. Now, the returning candidate makes the systematic appeal that the electoral speech that was given by the winning candidate was given on the ground of religion. Now, this a larger bench reference is made by the five judges bench in the Supreme Court, and the current bench of seven judges bench is hearing this particular matter, and they are defining the scope of the term his. That we highlighted, that is used in the Section 123 Clause 3 of the Representation of People Act. Okay. Now, basically, these two petitions, one election petition arising in 1992 and another arising in 1995. These two petitions are taken together along with are taken together, and these are lying before the judges, seven judge bench in the Supreme Court of India, which we are discussing now. Okay. Now, court is herein looking at the interpretation of what is Section 123 Clause 3 saying, and what is its main purpose, main motive. Okay, because the core allegation was that one Abhiram Singh, who was contesting from Shiv Sena, he appealed to voters on the ground of religion, invoking Hindutva and portraying Hindus as a distinct political and cultural community. Okay, and he basically sought the votes from the people belonging to the Hindu religion. Okay, so we are looking at the majority view first, and then we will also discuss the minority view, because Justice Chandrachud is authoring the minority view on behalf of Justice Goyal, Justice Lalit, and of course him. And now this Abhiram Singh, he invokes the religious sentiment using Hindutva as a political ideology, and then he also implicitly, denigrates other religions, and then the statements were made with his consent by his allies as well. Okay. Now, basically, it is alleged by the one who is opposing such elections, such election of Abhiram Singh, is that it is promoting division among community. It is basically a step to sort. And influence votes on the basis of religious identity, and basically an appeal to vote for the candidate on the ground of religion is violative of the free and fair elections, is violative of the principle of democracy as well. Okay. Now, Bombay High Court dismisses it, of course, and then that's why it is coming to the Supreme Court. The election petition gets dismissed by the Bombay High Court also. Now, earlier also there are few cases. Okay, there is one very famous case of Prabhu versus Kunte. It is, the full name of the case goes like Ramesh Yashwant Prabhu versus Prabhakar K Kunte. It is a 1990s judgment, and it is based on the speech by Bal Thackeray. Okay, and there were again divergent views on the term his, that whether it is the candidate's own religion or it includes the religion of voters as well. Okay, Prabhu versus Kunte is also one good case you can look at when you do Section 123 Clause 3. Okay, now basically court is considering that there is a mischief that legislature intended to prevent by enacting Section 123 Clause 3. The broadening court is also considering that there is a broadening use of religion or broadening use of caste, communal identities in election campaigning across India, whether it's explicit or implicit, that is happening in India. And there is a need that the court is observing here and to, protect the constitutional fabric, protect the constitutional fabric of the secularism. Court is also laying emphasis on the case of S.R. Bomai versus Union of India, in which secularism was pointed out to be one of the major important principles in the basic structure doctrine. Okay. So basically, just the majority opinion, now coming to the judgment, it is holding that the term his, okay, the term his in section 123 clause 3 that we were discussing, it is not just the religion of the candidate, but also it is the religion of the voter as well. Okay, so term his is not limited to candidate alone, but it needs to be read broadly to include voter or any other person or opponent as well. Because if I say he belongs to XYZ religion, and you should not and you are smart enough to vote for him. Now I'm not talking about my religion, I'm not talking about your religion, but I am talking about somebody else's religion. So that the majority opinion is covering in its scope, saying that it has to be read broadly to include the voters or any other person. Courts are emphasizing that the first step to of democracy, first step to having a democracy and also further having secularism is election. And the state has a duty, because we have a tenet of secularism, state has the duty to separate religion from the politics. Okay, now invoking religion, caste, race, community or language during elections is a corrupt practice, regardless whether you are referring to my religion, my caste, community, or whether you are referring to any other's caste community. If as a voter you are referring to my caste community or religion, race, etc., that is also violative of section 123 clause 3 of the Representation of People Act. Okay, so now the secular ethos of the constitution and the purpose that we do have electoral laws is being preserved by the majority opinion in this judgment. But however, there arises a dissent. Okay, now the dissent herein, the dissent comes also as a very powerful dissent in this case, because ultimately when we are talking of, okay, so basically, yes, we come to the minority view. Now, ultimately, when we are talking of, when we look at election petition cases, okay, the conclusion is that when you have used corrupt practices, it leads to disqualification. Okay, now the court herein is basically saying that election petition, when there is an allegation of corrupt practices used in election, it leads to quasi criminal nature of cases, because there is a penalty. Okay, the penalty is disqualification, etc. And then section 1, because whenever there is a rule of strict interpretation, okay, now this case is also important for the purpose of interpretation, because your majority view, the 4 judges, they are relying on the mischief rule. Okay, so they are identifying the mischief in the law and they are fixing it. But when we are looking at the strict interpretation rule that is being adopted by Justice Chandrachud in this judgment, we know that when we study rules of interpretation, we do study that for criminal statute, for penal statute, there should be a strict interpretation. Okay, so if the accused is fitting in that interpretation, only then he will be made liable. So Justice Chandrachud is basically saying that, because it comes, this particular provision comes with a penalty, violation of 123 clause 3, violation or practicing of 123 clause 3, that is a corrupt practice of invoking somebody's religion to gather votes or to discard somebody's votes. That is a corrupt practice, and that is a that is penalized. Okay, so when you are doing a construction in that regard, that construction must follow the strict interpretation, that construction must follow the literal sense. Okay, so now in this case, the minority opinion is basically saying that penal provisions are required to be construed strictly. The word his does not mean a broader meaning covering any person or the voters as well, but it should be construed narrowly to include only the religion of the candidate or his agent. Okay, now the dissent is cautioning against judicial overreach, stating that we should not write, as judiciary, we should not write electoral statutes under the guise of interpretation. That is also one caution that the minority judgment is bringing out. And it is basically saying that if you also, when we curb the practice of speech, okay, because ultimately it is happening in the form of electoral speech expression, when we are putting larger boundaries on it, when we are putting a broader interpretation of the term his, which includes the candidate as well as the voters, it could lead to unnecessary criminalization of speech in the political sphere, because that religion is always a touchy issue. Caste community is always a touchy issue in a geopolity like India. So that the dissent is warning that a broader interpretation could also lead to unnecessary, unwarranted criminalization of speech, and therefore the construction should be narrow as to include has to include only the candidate when you are interpreting his candidate or the agent. Okay. But however, the majority opinion held that the term his shall be read in a broader manner to include the candidate as well as any person or any voter as well. Okay. Now, this judgment is basically a step forward to curb identity based appeals in the elections. Okay. It upholds the idea of democracy by upholding free and fair election and discourages communal and divisive campaigning, reaffirms the secular fabric of the electoral democracy. And but also, when you look at the implications of this judgment, it is also triggering some kind of debates on freedom of expression, freedom of political expression versus reasonable restrictions during the electoral process, right? Because, after we have 19 clause 2, where the grounds are given for for curbing the free speech, curbing the expression, we have 123, where we are also putting a check on the restriction, we are also putting a check on the free expression. So that debate is needed. That debate is basically triggered, seeing that whether you have to give the political freedom of political expression, or how would you impose reasonable restriction during the electoral process, right? Now, this is it for the judgment of Abhiram Singh versus CD Commachen. I hope this discussion is useful for you. This was based on the Representation of Peoples Act 1951, and it is numbered at 67 in the list of AOR leading cases. For more such videos, please stay tuned with us on Legal Darshan. Thank you for watching. Have a great